conference, which relates to an extremely important issue, the state and understanding of public international law from the perspective of Central and Eastern Europe. This issue is the subject of research coordinated by Professor Aniko Rajs. I'm also glad to be able to cooperate in this area with Professor László Trocsányi. Thank you very much for this opportunity. The topic of my speech is international cooperation, and in particular, one of its forms, which are international organizations. States participating in contemporary international relations have at their disposal three basic instruments of cooperation. These include an international agreement, diplomacy, and an international organization. My speech is dedicated to international organizations as an instrument of cooperation between states and other subjects of international law. One of the main issues in this respect are the attributes of an international organization determining effective international cooperation. International organizations as instruments of international cooperation are, as a rule, established by states in order to achieve specific goals in foreign policy. It is not an easy undertaking. The goals set are sometimes ambitious and their implementation difficult, sometimes even impossible. However, an international organization must be equipped with certain minimum attributes that will enable it to function in the international community and at the same time to take action that have legal effects. The most important aspect is that international organizations operating in the contemporary international community are subjects of international law insofar as the states that create them under the international agreement provide them with attributes to undertake specific actions in the area of this law and international relations. The literature lists three such basic attributes: jus tractatum, the right to conclude international agreements; jus legationis, the right of passive and active legation, that is the right to receive and send diplomatic representatives; jus standi, the right to bring international claims and the obligation to incur international liability. Interesting considerations on this subject are formulated, among others, by Professor Judita Kuźniak, Marcin Worcinko, and Milena Ingelewicz-Sitak from the Jagiellonian University in Krakow. The same attributes are, of course, enjoyed by states in the sphere of international law. However, the scope of granting them to an international organization determines the power of the bodies and consequently the effectiveness of actions. All these attributes comprise the issue of subjectivity in the light of international law. Of course, international organizations do not enjoy the same scope of subjectivity as states, which are the only original subject of this right. As it is emphasized in the literature, the subjectivity of intergovernmental international organizations has been assigned by the member states and has a scope defined by them. The existence of an international organization depends on the will of the founding states. An international organization will be created if states decide that the organization is capable of being subject to certain rights and obligations, and that it has the ability to produce legal effects by its own action. The subjectivity of the organization is therefore derivative, not primary. In addition, a very important element in considering the effectiveness of international cooperation within international organizations concerns its legal capacity. In this area, there are fundamental differences between primary and derivative subjects of international law. The scope of an organization's legal capacity results from the provisions of its statute, from the goals set for the organization, and from its powers. The extent of an organization's ability to produce legal effect is not identical to that of a state. Individual organizations also have different scope of legal capacity. The legal capacity of international organizations is limited in relation to that of the state. And this limitation varies in the scope for individual organizations. In conclusion, it should be stated that the subjectivity of international organizations derives from the will of the state that created them and therefore has a derivative character, and that is limited by the function that, according to the statute, a given organization is to perform. Sometimes the text of the agreement establishing a given organization contain provisions on legal personality and legal capacity in the area of internal law of the states. Article 104 of the United Nations Charter can be quoted as an example under which the organization shall enjoy in the territory of each of its members such legal capacity as may be necessary for the exercise of its functions and the fulfillment of its purposes. However, the most important attribute of an international organization, which determines effective international cooperation, is the right to adopt legislation by the bodies of such organization. If the organization has such powers, achieving the goals for which it has established becomes realistic. Although the resolutions of the bodies of international organizations are not listed in the statute of the International Court of Justice as the basis for adjudication from which the doctrine derives the catalogue of sources of international law, they are considered as such if they meet certain conditions. The literature lists 3 of them. It is a resolution of an intergovernmental, not non-governmental organization. It is a binding resolution and therefore not an appeal or a resolution whose value is embedded mainly in the moral or political sphere, and legally it constitutes at most a de lege ferenda postulate. It is a resolution of a normative lawmaking nature, that is one of that creates and not only applies legal norms. By way of illustration, a resolution of an intergovernmental organization on admitting a new member to the organization, despite the fact that it is a resolution adopted by the government organization and is binding, is not a source of law, as it does not create new legal norms, but is only an application of the statute. This system has developed most extensively relatively in the European Union, where regulations, directives, and decisions have the status of supranational law. In classical international organizations, the resolutions of the organs are not always directly enforceable. Sometimes states retain the right to withdraw from applying these resolutions. However, most of the adopted resolutions concern the standardizing of technical issues, and their content is negotiated so as a rule, it does not raise any objections in the implementation process. Effective international cooperation actually depends on the adoption and implementation of such resolutions in such areas as, for example, technical cooperation in the field of international transport or civil flights. In conclusion, it should be stated that international cooperation within an international organization needs to be formalized. Therefore, the states conclude international agreements to define the legal foundations of this cooperation and the rules governing it. Permanent bodies distinguish an international organization from their cooperation instruments such as diplomacy. The last one has the character of bilateral cooperation, whilst within an international organization cooperation is multilateral. Therefore, it allows for dialogue between a greater number of entities participating in international relations. In the practice of international organizations, cooperation is a permanent dialogue between the states participating in a given organization. A feature of cooperation includes also a certain permanent agenda of sessions held by collective bodies, marking the next stages of international dialogue. Cooperation procedures can, of course, cause some difficulty. However, these are mostly carried out on the basis of acts of internal organs, which can be modified quite easily in comparison to international agreements and according to the needs of effectively implemented cooperation. States cooperate in the area of international relations, implementing strictly defined goals of cooperation. The historical development of such institutions can indicate the integration of states due to common goals that can be more easily achieved when states cooperate with each other. Obviously, an international organization is a certain legal and structural form of international cooperation. This form enables the stabilization of that cooperation, and this in turn facilitates the achievement of its goals through joint actions. There are many international organizations globally, which are the legal forms of international cooperation, ranging from universal organizations such as the United Nations and its specialized organizations to a number of regional organizations centered around a group of countries geographically and culturally operating in a given region. Naturally, the goals of cooperation in these two cases will be different, just as the principles of axiology on which the countries of the region are based will also be different. At the same time, it should be stressed that the goals of international cooperation are evolving. Changes take place depending on the needs of the changing reality. Nevertheless, the need for international cooperation has remained unchanged for centuries. In my speech, I highlighted only some of the trends relating to the essence of the operation of international organizations as a form of international cooperation between states and other subjects of international law. I have included more considerations on this subject in the study, which will be a chapter in the book edited by Professor Aniko Raisch. I had the honor of meeting you, some of you in person also before. Thank you again for the opportunity to cooperate with the University of Miskolc, which is one of the leading law teaching and research centers in Europe. This time my official duties meant that I had to stay in Poland. However, I hope that I will be with you personally at the next conference organized by the University of Miskolc. I also invite you to visit Poland again. I would like to thank you very much for your attention.